Thank you. All right, welcome to our first webinar session during the COVID-19. Our webinar is a panel discussion. So we have two panelists, and we're going to have the moderator telling you a little bit about them. But our panel discussion today is about lock it or risk it. So it's all about how you're going to protect your data. So my message is not very long. I just want to make sure that, you know, during this time, we do have a lot of fraud going on. We have cyber attacks, we have data theft, but how are we going to safeguard ourselves? How are other organizations going to safeguard our data? And we're going to have some presentation from two lawyers, and they're going to tell you what is happening within the organization and what kind of policies are put in place to safeguard our data itself. All right, I'm going to hand over to the moderator, and that's Miss Jody Ann Allen, and she's the Executive Vice President for the ISOC Jamaica.
Hi everyone, good afternoon, good morning, and good evening, wherever you are in the world. Thank you for joining us today. As Natalie said before, we have two panelists, Miss Justine Collins and Mr. Bartlett Morgan. Miss Justine Collins is an attorney at law with an impressive resume of professional membership, research, publication, and presentation. Among her many accomplishments, Justine has published articles for International Journal of Law and Information Technology, presented to the EU GDPR Institute Data Protection Workshop, as well as made submissions on the Data Protection Bill to the Jamaica Joint Select Committee of Parliament. Justine is a member of the Caribbean Blockchain Alliance, ISOC Jamaica chapter, Jamaica Computer Society, Jamaica Bar Association, and the Commonwealth Lawyer Association. Welcome, Ms. Justine Collins.
Thank you for having me.
Most welcome. Mr. Bartlett Morgan, the gentleman with the two last names, is a senior associate attorney at law who is a respected thought leader on digital law and policy issues. Among his many accolades, Bartlett's wealth of experience extends from being his firm leader on digital law matters to advising leading regional and international entities on complying with data protection obligation, enforcing intelligent property rights, and navigating various telecommunication and digital media frameworks in the Caribbean. Welcome, Mr. Bartlett Morgan. Thank you for coming to this panel discussion today.
Well, thank you very much for having me. It's really my pleasure to be here.
Okay, so we will start with you first, Miss Collins.
So Mr. Morgan is going to start our discussion rolling with a general overview of data protection regionally. So I'll hand over to him. Bartlett. Oh, Bartlett, I don't think we can hear you.
Yes, so I'm just going to pull up my screen there, and I hope you guys are seeing that. So essentially, what I want to do today is, in the next few minutes, really, the next 10 minutes or so, to kind of give you guys a sort of big picture framing of what's going on these days and why. I don't know if Now, if only I could get this slideshow to actually start, it would be perfect. Ah, there we go. So that's essentially what I'm looking to do today. What are the key global and regional trends? And in the larger scheme of things, well, why are we here today? So that's a little spiel about me there. That's not relevant anymore. So essentially, this here is what we're looking to do. We're looking to frame it in terms of like making sense of why any of this stuff matters in the first place, to be honest. And then we're going to be looking at two of the larger trends as regards data privacy globally and regionally. And then hopefully, I think after Justine's presentation, hopefully we can just have a more open-ended conversation about the whole thing and what it may mean for you and your organizations. So let's start with the why. Why does any of this stuff matter? Why does data privacy matter? Why are countries passing data privacy laws? What's the whole deal about? So there are a number of ways you could tackle that, but I would say from experience, the sort of most critical reason is trust, really, and trust in a multifaceted sense. So there is trust between, let's say, an individual and the different apps and websites and what have you that he may interact with, and the degree of trust will determine the degree to which he will use those different things. And then there's trust in the broader societal sense of a recourse. So I trust that if I use your service and something goes wrong with my data, that there's some recourse. So there's trust in that sense as well. And that is in large part one of the critical reasons why you would have jurisdictions want to pass privacy laws. Outside of that, there is just the more practical. So whether you know it or not, we all have privacy rights. Whether or not there's a privacy act in your jurisdiction or not, you have certain rights. And these are, based primarily in things like your constitution and the common law for the most part. But the problem is that's very vague. You don't know exactly what the boundaries are. And then just being more practical, it's really a kind of expensive approach to enforcing your rights if you think there's been a breach of your rights. And so all of that, it makes for a kind of unhappy sort of situation or state of affairs. And so enter data privacy laws, which essentially outline in a more clear way what the exact rights are that you have and so essentially the boundaries of the rights that you have as a citizen relative to other persons as regards your privacy rights. And so in large part, that's a big part of why all of this matters. And then to contextualize it just in terms of like the overall economy of the jurisdictions, we're in the midst of a COVID-19 global pandemic. And whether you want to or not, pretty much everything is digital now. And so we are in some ways kind of living in a world where everything is mediated by digital means. Paying for stuff, getting different services, it's primarily digital now. And that is part and parcel of what people refer to as your digital economy. Basically doing transactions mediated by, modern technologies, that kind of a thing. And so what you find, the research shows that people tend to sort of transition from the traditional economy into the digital economy more when there are things like a privacy framework in place to kind of make that transition easier. And so that's one of the reasons why it's a big deal. So let's get beyond that for a second and let's get into the nitty-gritty. So what you're seeing here on your screens now essentially is a diagram indicating the amount of privacy laws that have been passed globally, decade by decade. And so what you kind of realize, without me even giving away too much, is that essentially growth, especially in the past 2 decades, has been exponential. So, in the late 70s and into the 80s, privacy was really just a curiosity that the Europeans cared about. Nobody else would talk about this stuff. In the 90s, the Australians got on stream, stuff like that. There was more of a large-scale conversation. The UK, they were amending their act, all of that stuff. And then in the 2000s, that's when things really blew up. And so that's one of the major trends that you see now. Everybody everywhere is passing privacy laws and premised in large part on the kinds of things that we've discussed before. And in the Caribbean, we have other reasons why this is the case. And we'll get into that into a little bit. So globally, you have all the major jurisdictions taken steps to put privacy laws in place, or they already have put them in place. And obviously, the glaring example is the GDPR out of the European Union. In California, they've passed a CCPA. In Brazil, they've recently, passed a widespread data privacy law, or rather, data privacy law with widespread impact. And this is the general trend of the world. China as well. They have a series of legislation that protect you, your right to privacy. And this is where we're going right now. In the Caribbean, it's actually more or less the same. Now have a look at this. So on this screen, what you'll see is essentially a mapping of when different jurisdictions were passing privacy laws. And you realize that fairly more or less in sync with what's happened globally is that there wasn't much action at first. In the early 2000s, we had two jurisdictions. I believe that was the Bahamas and St. Vincent. They passed privacy legislation, and then there was just total quiet. And then in about 2010, the ball started rolling again, and different jurisdictions. So two jurisdictions passed that year. The year after, two more. A little bit of quiet, and then in 2013, two more. And then there was a little bit of quiet again in 2014 to 2015, and then by 2016, it started again apace. And in fact, this diagram probably needs updating, because since this diagram, I put this one together, the Barbados would have passed a substantive act as well. So that needs to be added to this as well. And so the point is, we are essentially tracking what's going on globally within the Caribbean. And there are some factors that are kind of specific to our situation that have been propelling this. So for example, most Caribbean jurisdictions sign on to something called an EPA with the European Union. One of the things that they asked us to do was essentially to pass privacy laws. And so in compliance with that, different jurisdictions around the time, because we've signed the EPA in 2008. So if you look, you realize that pretty much most of the action started after that time. And so essentially in the Caribbean, we have been taking steps towards sort of the general direction that the globe is going in terms of the overall trend. And we are pretty much in sync with that trend. In Jamaica itself, Justine will get into the details of this in a bit, but you guys have a bill before Parliament right now, and so as soon as that becomes the law, then you will be part and parcel of the, the data privacy club. There are other jurisdictions as well in the Caribbean who aren't there as yet, but they're getting there. So for example, Suriname, they've also tabled draft legislation, and theirs is very much, you could say pretty much, in sync with like the GDPR out of the European Union and so on. And that is where we seem to be going. So what I wanted to touch on finally, in terms of the big picture, was essentially, let's see, oh, perfect timing. I have 2 minutes left, so I'm gonna have to push through on this. But essentially, what are we seeing in these newer bits of legislation? And with reference to stuff we see in the Caribbean and even more generally, what are we beginning to see as the features? So I've listed here some of what I consider to be some of the more interesting features that we've been seeing popping up in newer legislation, i.e. within the past 10 years. And perhaps I should say within the past 4 or 5 years. And so perhaps the main one is this whole notion of extraterritoriality. That is, quite frankly, the only reason why all over the world and in Jamaica, we talk about things like the GDPR, because the GDPR has something called extraterritoriality. And all it really means is that even though countries typically make laws to guide their affairs within the country, extraterritoriality says that even though you're outside the country, the laws may apply to you in certain circumstances. That's the basic idea. And so we saw that pop up in the GDPR in a big way. And we've seen other jurisdictions follow suit since. So for example, the same California, they have extraterritorial provisions within their laws as well. In New York, the New York Shield Act essentially has those kinds of provisions. And even here in the Caribbean, the Barbados Act that was passed last year, it has provisions that essentially speak to extraterritoriality as well. And I'll probably even go further to say the Draft Act in Suriname, it also has this kind of thing in it. The other issue is, well, the reality is big fines. A big part of why organizations are sitting up and paying attention nowadays as regards data privacy versus, let's say, 10 years ago when it was a non-conversation in the boardrooms was because of the size of the fines. So, I mean, what you'll notice is that if you look at the map of jurisdictions that are passing privacy laws, all the more recent ones have far more significant fines than before. So in the Caribbean context, for example, St. Vincent, their fines were a big fat zero. There are no fines in their act, and they were one of the first ones out of the gate. Now, the other extreme is a Barbados. They just passed their act, and their fines are in the region of about 250,000 US dollars per breach. So it's no longer something to laugh or scoff at. Depending on the jurisdiction you go in, it can be even more severe. We use the international example of the GDPR because it's just easy to refer to, where you have fines that go up to sometimes maybe 4% rather, of your overall turnover in a given year. In Trinidad, they use a similar structure in their act as well, where essentially it's a percentage of your turnover or your profits that will be used to determine the penalty. Now, my time is up, so I won't get into the details of the rest of these things right now, but I'll be happy to jump into all of this later. So I guess back to you, moderator.
Thank you so much, Mr. Morgan. That was a very informative discussion. Thank you. I have a few questions myself on what you have presented here, but now I will have Miss Justine Collins' presentation, and then we'll go into all the questions that I have to ask along with others. Miss Collins, to you.
Thank you so much, Bartlett and Jodianne, for that excellent introduction. I'm just going to set up my screen so that I can share it. Just give me 1 second. I'm sorry, Otis, is there an option where I can share my screen?
It's to the
Does
bottom
it say,
of your screen.
It says host disabled participant screen sharing.
Yeah, so maybe if we just made her a host real quick, she could.
Okay.
Oh, there she is. Perfect.
Okay, can everybody see the slideshow?
Yes, it's coming.
You can see. Yeah.
Okay, great. All right, so thank you so much, Bartlett. I think that gives a very great high-level view of what's going on internationally as well as regionally, and provides the relevant context for us to look at what's happening here in Jamaica. I have 10 minutes as well, so I'm going to try and be as brief as possible. So Bartlett mentioned that there was a wider context, a wider policy overview that we are operating in. CARI Forum signed an EPA with all of an economic partnership agreement with all of the different countries in the Caribbean, which required that they institute certain data protection laws. So that's why we'd see the laws coming up here and there across the region. And in Jamaica, we promulgated a bill in 2017. So all of the provisions here are based on the last public draft. There are still discussions at the Joint Select Committee level, and we haven't passed it as yet. So none of this is actually law right now, but this gives a sort of high-level view of what we can expect when it's passed. So I wanted to go through just some very, very basic features of what we can expect in the bill. Data controllers. And I know most of us here are technical persons, and we'd want to know, how does this apply to us? Are we data controllers? Are we data processors? So data controllers are can be a natural or legal person who either alone or jointly or in common with persons determines the purpose for which and the manner in which any personal data are to be processed. Now, this is in direct contrast to data processors. So you may have situations where you're outsourcing IT functions and you're not actually the entity that's determining the purpose and manner in which it is processed. In that situation, the outsourced IT function would be a data processor rather than a data controller. Now, personal data is also very important. Is all data personal? Not necessarily so. Data that is related to a living individual who can be identified from that data or which enables identification of that individual when taken together with other information. So you can have some information out there if you have, for example, a National Insurance Scheme number, NIS number, and you also have other information about that person, and you realize that from all of that information, that person is Justine Collins. That would make that data personal data, depending on what the data controller has in his possession. And processing, also very important. It can be anything from obtaining, recording, or storing information or data. It can also be loading data on a page. It can be retrieving, organizing, and adapting data. It's a very broad definition of processing. And we see in other cases, such as the Google Spain case, where they've applied this sort of very expansive view of processing to even include Google searches that could be deemed as processing. So the indexing of the searches on a Google page can be processing. Very, very quickly, there are certain data protection standards that data controllers are obliged to adhere to. There are various obligations within the bill. And the bill is very lengthy, so I didn't want to go into all of them, but I wanted to just give a very brief contextual overview. One of the biggest things that we look at is fair and lawful processing. And fair and lawful processing is the first standard, and it requires that the data controller lawfully process personal data. That would include, one of the ways in which you can lawfully process data is by getting the consent of the data subject. And consent is something that has been subject to various definitions depending on which jurisdiction you're looking at. Our bill right now is based on the 1998 UK Data Protection Act. So it tends to be a little outdated. I'm presuming that it might be updated depending on how the discussions at the Joint Select Committee goes. So our definition of consent right now is just express consent obtained from the data subject. If you look at the GDPR standard, for example, the standard is sort of a medical standard of consent. It requires informed consent that is unambiguous, clear, freely given. And it also incorporates withdrawal of consent options. So it's a much higher standard than what we have in our bill. In relation to the purpose, the data that is collected should be for one or more lawful purposes, which is communicated to the data subject at the time of collection. Data minimization, and that just says that any personal data that you're collecting should be adequate, relevant, and not excessive in relation to the purpose for which it's collected. Accuracy, it kind of says it all. The data collected should be accurate and kept up to date. There's a storage limitation, which says that the personal data shall not be kept for longer than is necessary for the purpose of processing. In our bill, we have some provisions that allow for standards to be set. So I know that there's contemplation for different sectors to set standards as to the length of time that is appropriate for the retention of data. You might have different considerations for financial data as opposed the financial sector as opposed to other sectors, depending on their anti-money laundering obligations. Compliance, this one requires that all the provisions in the data protection bill and the rights of the data subject are complied with by the data controller. Security, the data controller should ensure that there's appropriate technical and organizational measures for the protection of that personal data. So it not only requires you to have your technical systems in place, your antivirus, your monitoring, reporting, etc., but also your organizations, your people should be trained as to how you collect and store the data and how it is to be safely used. And data transfer, and we talked a little bit about the extraterritoriality component with Bartlett. Here in the Jamaican bill, it requires that personal data of Jamaican data subjects is not transferred to a country outside of Jamaica that doesn't have the adequate freedoms and guarantees that we have in our bill. Another thing I'd like to note as well is that generally speaking, this act only applies to Jamaican data controllers or controllers that have servers in Jamaica. All right, so just some of the rights of the data subject. Now, data subjects in Jamaica have a right to access personal data for a fee if applicable. So they have a right to say, okay, hey, are you processing any data about us, about me? What's that? What is that data? And they can get a copy of that data if necessary. There are certain exceptions which may apply depending on what sector you are in, etc. There's also a right to prevent processing likely to cause distress or damage. Very interesting because there have been a lot of cases on distress and suing for emotional distress and damage and the limits and the scope of that. So there is that right in Jamaica. Based on our case history, I'm not sure how far the suing for emotional distress would go. We'd have to see depending on how the courts look at it and how the courts take, for example, some UK decisions and apply it to our situation. The right to prevent processing for purposes of direct marketing. And I can tell you this is one that I'm waiting to use because I'm so tired of getting these texts and SMS messages and emails just constantly bombarding me because I think somebody is texting me, but it's really just a bigger, better network. So that is one of the rights that we'll have. Rights in relation to automated decision making. So if there's an automated decision that's made about you, you have a right to question that logic and what is behind the reasoning behind it. So, and the right to request rectification of inaccuracies. This is something that I suppose we'll go into a discussion about the GDPR and the rights under that at some point during the discussion. But this is our version of the right to be forgotten, which is very, very topical. So it doesn't arise to the level of a right to be forgotten or erased. It's more so a right to request a rectification if anything is, any data that they have about you is wrong or incorrect. All right, so we talked a lot about the liabilities and the penalties. And Bartlett talked about the fixed sum that Barbados has, for example. We have taken a percentage model. So if it is that a company or data controller is found to be in breach of any of the provisions under the Act, the company may be liable to a fine not exceeding 10% of annual gross income. That is also in addition to the possibility, depending on which breach happens and the provisions of the Act, there's also possibility for criminal sanctions in terms of imprisonment, etc. If that offense was committed with the connivance of or neglect of a director, manager, or secretary of that company, that person may as well be punished. So what this shows us is that at the board level, we have to be mindful of what is going on in our organization. What kind of policies are we setting and what kind of systems do we have in place? Because there could also be personal liability for directors. There's also the possibility of civil liability. So if a person suffers damage by reason of the contravention, they can file a lawsuit and they may be entitled to compensation, depending on whether they are successful or not. Now, I wanted to wrap up with just some of these questions, which would probably get I'm sure you have some questions already, but just to give some food for thought and to start the ball rolling on this panel discussion. Think about your organizations and how you're storing data and storing information. Where are you storing this information? Where are you storing the data? And how is it separated within your firm? What technical, physical, and administrative protections are in place? What do you have? Have your people been trained? What organizational measures do you have? What's required to maintain the integrity of these protections? So do you have checks and balances in place? If you have an inventory of the digital assets, that's also very important. And I wanted to talk about this concept of cybersecurity risk assessments. In our bill, we have a data protection impact assessment report that's required to be filed every year and filed with the Information Commissioner's Office, which will be a new office created by this act. So we need, all organizations are required to register with the Information Commissioner and file these data protection impact assessment reports. Do you have a cybersecurity policy? Do you have a data protection policy? Do you have an incident response plan identifying persons within your organization who are responsible in the event of an incident? Do you have cyber attack insurance? There are a number of local insurance companies that are now offering this. It's something that we are considering for our organizations. Professional indemnity insurance for example, lawyers. Does it cover cyber attacks and hacking? So those are my 2 cents, and I will open the floor to any questions and discussions that we can have now. Thank you.
Thank you so much, Ms. Collins. Very informative presentation, and I am concerned about where we are as a people, as a nation, with legislation to protect each and every citizen, because everyone needs to have protection. We are going into the question and answer section, which will be open and free for you to ask your question. Just indicate that you need to ask a question. I see Ms. Jacqueline Morris has a question. Go ahead, open your mic and ask your question, Ms. Morris.
Hi, everyone. Good afternoon, and thank you for the very informative presentations. Now, there's one thing that has been coming up a lot recently, which is the one and only e-identification that allows the government to manage all of the data they collect on you via this one identification number. In cases of places where you have choice, I can choose to give Amazon my information or not. I can choose. With regard to health services and government services, we don't really have much choice in dealing with some of these things. You can't really choose to live outside the education system or totally outside the health system, or not drive a car or not have a passport and that sort of thing. Do these laws apply to governmental management of data, and if so, how?
So I could jump in there on that one. So the short answer to your question is, when you think about someone processing your data under any privacy law, one of the first things you want to ask yourself is, what is their lawful basis for processing data? Now, you'd have heard Justine talk about things like consent and so on, which typically applies in, private interaction between yourself and, some commercial entity or what have you. But as regards governments, very often they have a number of other bases on which they may process your personal data. So, for example, if there is some statute or law that requires them to process it, that in and of itself is a lawful basis that justifies them collecting that information, regardless of whether you've consented to it or not. So consent is simply one basis, but there are a number of other bases. The governments would typically fall underneath one of those other bases.
But
Yes.
what would be my recourse if, part two.
Sorry, I
what
just
would be my recourse? Okay.
I just want to reiterate what Bartlett is saying, that in the bill that we have right now, there is a public interest basis as a lawful ground of processing data. So that might be one, as well as if you're talking about health, there might be the vital interests ground as well. If it is that it's necessary to preserve the vital interest of that data subject, which could be life and death sort of situations. So there are a number of other grounds for lawfully processing that data, aside from consent. Yes, Jacqueline, continue.
Okay, but if the government mishandles my data, what sort of recourse would I have? Would that be a major court case, a constitutional motion? Would I have recourse? If they insist on collecting data?
The short answer is that it Yes, to all of those things. I mean, a Privacy Act doesn't remove, for example, your right to a constitutional motion if, for example, the person who's breached your right is a governmental actor. So you can use the Jamaican example recently. You guys will recall a case called Robinson versus the Attorney General. That's an example of that, where you bring a constitutional action against the state. But realistically, in the context of privacy legislation, the privacy legislation will usually have mechanisms for you to, one, make a complaint to a regulator, usually something like the Information Commissioner or, something like that. And they will then run with it, investigate it, and then, sanction the person if there is in fact a breach. And then in addition to that, many data privacy laws in the region, including the draft one in Jamaica that we've seen, it says, well, you also can bring a private action against the person who's breached your rights.
I'd like to ask a question, please.
Okay, go ahead.
Okay, we had some cyber attacks on banks about 2-3 months ago. Isn't it the right of the customers to know of what happened to their account? Because I think the only thing that was sent was something in the mail. Because you said that most organizations have cyber attack insurance, but isn't it a mandate for banks to let the customer know what exactly had happened to their account?
Okay, if I may, so our bill actually provides for that. If there is a data breach, the data controller is required to inform the data subjects of the nature of the breach, what was disclosed or what was breached, as well as also file a report with the Information Commissioner. So all of that, the details and the recourse, etc., that should be communicated with affected persons. I think you're speaking specifically about Jamaica National and Victoria Mutual Wealth Management. And I know that a release was sent, especially in the case of Jamaica National, where they even identified their data protection officer, which is a requirement in that report that you send to the affected customers as well as the Information Commissioner. So they've gone ahead even before the bill has been passed and appointed a DPO who is responsible for handling those kinds of complaints within the organization.
Okay, there's a question on a live stream from Nigel. He's asking if Jamaica will seek equivalence with the GDPR. I'm not sure if anyone could answer.
I'm not sure I heard the question properly. Could you repeat that for me, please?
You're not coming in very clear, Otis. You're not coming in very clear.
Okay, let me check something here. Are you hearing me now?
Yes, that's much better.
Okay. So Nigel is asking if there is, if Jamaica will seek equivalence with the GDPR.
So if by equivalence you mean essentially all the fundamental
align, yeah, if it seeks to align.
Well,
yes.
so
okay.
Align, hello?
Sorry.
Yes, go ahead.
Align is kind of an ambiguous term because if by align you really mean essentially the fundamentals are more or less the same, then the answer is strictly speaking no. There are some fundamental features in the GDPR that are not present or present in fundamentally the same way as they are in the draft legislation in Jamaica. So that is the short answer, that it's not perfectly aligned, but it's certainly going in the direction of it. That's my take on it. I don't know how Justine feels about it.
No, I agree with you. Our data protection bill is modeled on the UK Data Protection Act in 1998. And that is modeled on a EU directive from 1995. The GDPR came into effect in 2018. So you can imagine that there's a 20-year gap in terms of the new incorporations, there are new rights involved, there are increased standards. I mentioned consent during the discussion. So there are increased standards, higher thresholds, higher penalties as well. So it's not necessarily the same regulation, but in terms of the norms and like the concepts like data controller, what's a data controller, what's a data processor, those sort of basic data protection norms are the same, but there's a sort of divergence between the GDPR and what we currently have before Parliament. But it is, as I said, it's a work in progress. There have been recommendations for some of the GDPR recommendations to be placed in our bill. I know that Jamaican Bar Association made recommendations such as the right to be forgotten. All of these new rights we're seeing in the GDPR to be incorporated in our bill. But it remains to be seen how the bill will finally look. As it stands, that's the basis. So.
Thank you. I have a question. I have a situation right now unfolding where our CUG network was compromised, and as such, personal information is out there in the digital world. What do we do? How do we go about protecting ourselves as an individual and as an organization?
So was it the subject of a hack?
We are still trying to understand what really transpired. We have taken it to the police station. We have done what we can do, but no one seems to be understanding what is happening. So from a technical standpoint, I want to know, how do I protect my employees? How do I protect myself? Because it seems to be synonymous with just our CUG network and not per se our personal phones.
Okay. Well, the Cyber Crimes Act, I think, would be applicable here. And just a question, have you reported it to the Major Organized Crime Agency, MOCA?
Yes, we have.
Okay, because those kinds of things, cyber attacks, hacks, and those kinds of, I guess, for lack of a better word, hacks again, those are really the subject of a cybercrime rather than a data protection issue per se. Right now, we don't have a Data Protection Act in place, so you wouldn't be able to seek recourse under that legislation. And it would really be a criminal matter for the police to investigate.
Okay, understand.
Okay. All right. Question in the chat. You're hearing me clearly?
Yes, hearing you clearly.
Okay. Ronald is asking, how does the ISO 27001 standards factor in the draft bill for Jamaica?
So there is a short answer to that, which is that you wouldn't be able to directly map all of the elements of ISO 27001 back to the Jamaica bill right now. And it relates to the conversation I guess Justine and I have been more or less having as regards, the equivalency, to use a word, with the GDPR. Right. The ISO 27001, it really maps directly to the GDPR itself. And so to the extent that there are certain features present in that legislation that aren't in the Jamaica bill, then you wouldn't be able to map every single aspect of it. The fundamental aspects, of course, because the core principles are the same. Well, most, but not all, are the same. So you could do some mapping, and you could go some way with your mapping, but it wouldn't be a complete one-to-one mapping the way you have with the GDPR, for example.
Yeah, I agree. The ISO standards are actually incorporated by the Bureau of Standards. So I think that they have some sort of acknowledgement that persons may be seeking to look for those standards and incorporating it in their organization. But from a legislative standpoint, I haven't seen anything to that effect.
Okay. Now, Nigel is once more asking, and I think maybe it's because Jamaica is a signatory to the UN. All right.
What's the question?
The question is, it was asking for formal equivalence where EU effectively gave Jamaica a tick in the box allowing enhanced data transfers.
Okay, so Jamaica is not presently subject to the approval of the EU Data Protection Commission, I believe. So it's not recognized. There's a list of countries. It's very short. I think it's Canada. The US has a privacy shield, and
Yes.
Sweden. Yeah, Bartlett, you can jump in at any time.
Yeah. So
These sorts of New Zealand, I believe. I can't recall all of them. It's about
yeah,
10
man.
countries.
So I mean, if I can frame the question correctly to make sure that I understand it, he's essentially asking about essentially the ability for transfers of data to go between, let's say, Jamaica and the European Union.
Right.
If that's the question, so there are a number of bases on which you can do that. Right now, we don't have the basis where essentially they certify Jamaica as a jurisdiction to say all transfers from Jamaica and to Jamaica are lawful. We don't have that certification as yet. So there's a limited number of countries that have it, and it would be to some benefit to have it because it would mean that, for example, for the BPO sector in Jamaica, which is huge, to the extent that you have lots of onshore entities in Europe, it makes it easier to onboard new clients and do new work without signing a new contractual framework to do with privacy protection every single time and paying a lawyer every single time. I mean, we have no problems taking your money, but it would make it a lot easier for you if you had that kind of transfer, that kind of certification in place, essentially.
For the country, that is.
Yes.
For the jurisdiction. But you can, as an organization, use the other bases, such as the certification of your operations. So you could get certification from one of the regulators in the EU, or you could use your standard contractual clauses and, as Bartlett says, bypass us. And every single time you are transferring data, EU citizens' data outside of the EU, you would have these sort of standard contractual clauses, which are available on the EU, is it the Data Protection Board website, I believe. So you could have those, they've pre-formatted them, and you just like literally just fill in the blanks. But depending on how much processing you're doing, it may be more relevant if you have like a one-off situation. So if you are, for example, in a law firm, you may feel like it's better for you to use standard contractual clauses. You're more familiar with that, and it's just easier because the amount of processing of personal data on a day-to-day basis you will do for EU citizens may not be as great as perhaps a BPO on every single day doing all of these various persons. They may seek certification of their operations because that's just easier than getting the client to sign these contracts every single time. So it really depends because we don't have that approval as a jurisdiction. So one of those two, I think, would be best depending on your processing abilities and the capacity in your organization.
Okay, thank you for that.
Thank you so much, Justine, for that answer to those questions. And Mr. Morgan, Bartlett Morgan, thank you so much again for being a part of this panel discussion. Does anyone on Zoom or live stream have any more questions? Okay, with that said, I would like to hand over the rest of this morning, evening, or afternoon session to Mr. Otis Osborne.
Okay, thank you, Jordan. Okay, colleagues, those on live stream, those who are participating or who participated in the Zoom session. Now we have heard all there is. I suspect there are much more regarding data protection, right? However, the GDPR has led the way in data protection regulation in a very big and impactful way. And of course, there has been a widespread enactment of data privacy laws across the Caribbean, including Jamaica. which is still to be enacted. We have, of course, we heard things such as consent now being required to collect, store, and use personal data, as well as compliance with policies and procedures of how data processors treat with data, as well as we have heard the mention of unsolicited messages, which is yet another issue of concern. And hopefully that is also addressed in our data protection bills. The matter of recourse, of course, is also very important as we seek redress to breaches in protecting personal data. I thank you for attending this session, and now I'll hand over to Andrea, who will give the vote of thanks.
Thank you so very much. It's really been a pleasure. This is especially important to me because I'm at the last lap of a fintech project that deals with data protection. And it's such a pleasure to find out that the region is moving along quite nicely as we all make our goal towards or stride towards development, develop status bit by bit. I have not much to say except a big thank you. Thank you for your thoroughness, your care, the practical way in which you answered the questions. And it's very encouraging, and it's great to know that we can deliver such vital information in a short time, in a manner that we all, as non-practitioners and practitioners, can appreciate and understand. I'm grateful for the growth, and I'm sure that all of us here feel the same way. Thank you so very much. And we encourage you to please come back and join us again, because ISOC continues to move forward despite COVID.
Definitely.
Thank you for having us.
Thank you very much. It was a pleasure.
Okay, thank you all once more.